Hey, what's up, everybody? My name is Onepeg, and in this video, we're going to be talking about all things related to the court dismissal of the United States' case of Nexon versus that of Iron Mace Games. To get everybody up to speed, Nexon is suing Iron Mace Games, or was suing Iron Mace Games in United States District Court in Seattle, Washington, over the fact that they claim that Dark and Darker, which is created by Iron Mace Games, stole assets in order to create Dark and Darker from an unreleased project at Nexon titled Project P3. Both companies are located in Korea, and the majority of, well, a third of the development team at Dark and Darker at one time worked for Nexon on Project P3, but none of this so far has been proven to be true. Anyway, we have an order granting the motion to dismiss the case from the judge, citing what is known as a forum nonconvenience. Now, the forum nonconvenience basically says or means an inconvenient forum. The location of the Seattle, Washington court was found to or deemed to be not the best possible place to have this case heard. At the same time as this U.S. case has been ongoing, there has been a second case, a sister case to this in Korea, where both Nexon is suing Iron Mace and Iron Mace is suing Nexon over the same exact things. Now, this is being litigated in a court located in Suwon, South Korea, which is south of Seoul, and the people involved in this U.S. case have been kind of going back and forth over this entire thing, with a couple of different reasonings as to why it should stay and why it should go. Now, the defense is represented by a guy named Aaron J. Moss, who also has a few co-counsels, but Aaron Moss is relatively known in the legal, sphere as a rock star when it comes to legal proceedings, even going so far as to be appointed to the Supreme Court to be able to litigate in front of the Supreme Court justices. Now, in this case, the reason why it was dismissed was because the judge agreed that the Seattle court was not the best possible place to have this case heard. But there were a couple of pieces here that I did want to bring to your attention. In this document, they cover a few different pieces, one being the legal ramifications of the DMCA and the rules surrounding the DMCA, and also whether or not a forum nonconvenience dismissal is warranted given what are known as public and private interest factors. The first ruling here in the discussion section of this happens to do with the DMCA. Now, they go through and talk about how there's a difference between personal jurisdiction and agreeing that the best possible forum is the Seattle court. Nexon's attorneys tried to argue that the Seattle court was already agreed upon as the best possible forum because, and I kid you not, the defendant, Iron Mace, responded to the DMCA to declare its lack of validity. Because they responded and said, no, the copyrights are our own, that meant that in part they also had to agree that the jurisdiction of the Seattle court was something that they conceded to, meaning that the Seattle court had authority. But according to Nexon's attorneys, that meant that they also agreed that the Seattle court was the best possible forum to have that case heard, which seems odd. And the judge agreed. Jurisdiction and venue are two distinct concepts, says the judge, and cites SEC versus Ross. The question of whether the court can exercise personal jurisdiction over a party is distinct from the question of whether the venue will properly lie in the court exercising jurisdiction. There is also a footnote further down in this that I do want to bring to your attention. And the footnote is located here, where she says, however, this case is distinguishable because Nexon's issue relates to a procedural impediment specific to the procedural posture of the Suwon case, while Irish National relates to the availability of adequate relief on the merits. What she's talking about here is the argument that the plaintiff, that Nexon had attempted to make, to say that they were unable to procure source code from the defense, trying to say that Korea was an inconvenient forum. It wasn't the best possible forum because in the pretrial preliminary proceedings, the United States could compel the defendant to produce source code to hand to the plaintiff for review. However, that is also possible in the Korean court. Nexon originally stated that it wasn't a possible thing for them to be able to do, and the defense simply brought up, well, you never tried to ask for it, and there's actually a procedure in Korean court where you could do that. Nexon then came back and said, well, okay, yeah, I guess we could have, but that's extremely time-consuming and not something that's typically done at this stage of the game. To where the judge agreed with the defense Well, you could have just asked for it. And this footnote here is a bit interesting of a read. The court is also suspicious of Nexon's true motives in filing this action in the United States in the first place, since it chooses to include a forum selection clause in its employment agreements limiting actions to the Korean court. Now, both Choi and Park, employees of Nexon at the time and the people that are named in this suit, signed agreements stating that they would litigate this in a Seoul, South Korea court should the need arise concerning copyright things. However, because they're litigating it in Suwon, the plaintiff attempted to argue that the Suwon court wasn't where they had agreed upon to do this originally, therefore it should be still litigated in the United States. But again, Nexon is suing Iron Mace in the Suwon court, so they've already agreed to a forum. Point is kind of moot. The court is not interested in using its limited judicial resources to allow Nexon to exploit the U.S. District Court's more permissive discovery rules in order to circumvent Korean procedural rules in the parallel litigation. Kind of a scathing hit. Now, when it comes to private and public interest factors, there's a few different things that are weighed, and the judge agreed with the defense in all of these cases. The first is being the private interest factors, is the people that are involved. Is this something that should actually be considered to get kicked out of this court into Korea? And the judge agreed that because of all of the information, for the most part, all of the physical evidence, etc., all of the witness testimony and all of that is already located in Korea, where the primary language for probably 90% of this case is spoken in Korean, it wouldn't make sense to try and have all of that translated very tediously and very expensively into English to be litigated in the United States unless such time were to arise, like, for instance, a Korean verdict of some kind. The second is public interest factors. Would the public benefit from this, and would it be taxing to the court? Is there a benefit to the public in having a verdict for future cases to rely on? And in this case, public interest, the judge said, would have some amount of an interest in the verdict in this case. However, that could just be transposed to the United States from the Korean court. So for that reason, she again sided with the defense. So we have an order here that says the court grants defendant's motion to dismiss on grounds of forum nonconvenience. The court dismisses without prejudice plaintiff Nexon Korea Corporation's complaint, and the court denies defendant's motion for relief from the initial disclosures deadline as moot. There was another motion filed to stay the discovery, where everybody has to get all of this information together. Remember, all the translating that would have to get done would be part of discovery. Now, they don't have to worry about ruling on that because this is already being dismissed due to the forum rules, and the rest of this is moot. So the discovery stay is not needed since the case no longer exists, basically. However, there are two interesting pieces here. One is that the court dismissed this without prejudice, and there's a reason why. Nexon asked the court to deny the defendant's request for dismissal with prejudice because it believes it will be required to reassert its claims under U.S. copyright law in Seoul District Court, despite the fact that it has already asserted essentially the same claims under Korean copyright law in the Suwon action. Nevertheless, the court finds it appropriate to dismiss this action without prejudice. So that's the first important thing. The second is that it appears that attorney's fees are going to have to get eaten by the defense. That didn't get forwarded over to the plaintiff, even though the judge said it was a little bit suspect. But the bigger issue here is this denying of the motion, or the dismissal, without prejudice. So what prejudice would mean is that if there was prejudice, it would mean that there would be penalties imposed on Nexon if they attempted to refile this exact claim again. What the judge is saying is that they could do that. She's allowing them to. And that raises a couple of interesting points. If they are allowed to be able to do this again, even though this was already dismissed due to an inconvenient forum, the question would then be, well, what else would they possibly have to argue here? If they refile it, the assumption would be is they would have something new to go on, something that would make it sound as though the Seattle court was a more convenient forum than that of Korea, which means that they would have to find something wrong with the Korean court process first in order for this to really be brought up again. If they were to bring it up again without any additional information, it's very likely, given the footnotes of what the judge wrote in this order, that she could end up reviewing this and kind of get miffed by it and kick it out, and then could possibly order this with prejudice. The second thought here, though, is about Steam. See, now that this case has been dismissed, the DMCA gets vacated. We've seen such in statements made by both the defense and the plaintiff who have talked about vacating the DMCA should this case end up being dismissed. And that's a real thing. Now, of course, the plaintiff could appeal this order, and it's likely that they would. I would assume that they're just going to keep trying to run the meter on the defense as best they can because billable hours are billable hours. But then the question becomes, would Steam relist the game? Legally speaking, there is grounds for Steam to put this game back on Steam. There's no reason why they couldn't do that because the case has been vacated, therefore the claim is vacated and the DMCA no longer has any standing. However, Steam being a private business that is interested in maintaining their own, I guess, ability not to be drawn into lawsuits. They want their own safe harbor. Steam that is interested in having that safe harbor provision could end up dragging their feet or outright refuse to relist the game because the case hasn't really been decided yet. See, because this litigation is still pending in Korea, the DMCA thing could end up coming back to the US if Korea finds against Iron Mace for whatever reason, even if it's preliminary injunction kind of stuff. But I would also argue in that case, it would then require a new DMCA claim, but I don't really know that. I'm not an attorney. I've never attempted to be one. I have asked around, and it seems as though the opinions are a little bit split. Legally speaking, Steam can relist the game. There's nothing wrong with that, and it doesn't violate any safe harbor provisions if they were to relist the game. But that doesn't necessarily mean that they will if they feel as though they might just end up back in the same position with a new DMCA request. You know, it kind of saves them time to just go, we don't really feel like potentially opening ourselves up to the liability. We'll just see what happens in Korea. They could do that. Now, whether or not there's grounds for a suit against Steam for not relisting the game and costing Iron Mace potential sales, especially now that the game is in early access, I don't know. I suppose that's really up to whatever the attorneys have to say. However, there was a letter that was posted from Aaron Moss, from the attorney, to any and all press folks, and luckily, I guess I got included in the loop, which reads, "Today, the United States District Court for the Western District of Washington dismissed Nexon's complaint against Iron Mace and its co-founders, Terrence Park and Joo-Hoon Choi. The court granted defendants' forum nonconvenience motion, ruling that Korea is the appropriate forum to hear the parties' dispute concerning Dark and Darker. We have long maintained that the U.S. lawsuit was a heavy-handed attempt by much larger game company to overpower its smaller competitor. We are gratified that the court recognized Nexon's litigation tactics for what they are, noting that it was suspicious of Nexon's true motives in filing this action in the United States in the first place. Fortunately, Nexon's bullying approach to litigation did not succeed. We are pleased that Iron Mace has been able to bring Dark and Darker to a global audience through its early access release on August 7th, and are hopeful that, with this ruling, Dark and Darker will be able to return to US-based gaming platforms soon." Now, I can tell you that the attorney's office is working on trying to get it relisted on Steam, and they are, at least from what this sounds like, confident that they will be able to succeed at doing that. But again, we don't know what Steam is going to do or how they're going to react. We can only hope that they see the legal side of this and realize that there is no, liability for Steam necessarily to relist the game, pending that the DMCA is no longer valid. Anyway, guys, that's what I have for this one. I have another video going up immediately after this that has to do with patch notes and a big pack of cool stuff that is being made available to everyone that enjoys Dark and Darker. So look out for that, and I'll see you live in just a couple of short hours. Okay? Thanks. Peace.